PowerPoint slides that you'll be seeing too. Okay. All right, got 2 minutes after. Christina, you want to get started?
Sounds great.
All right, thanks.
Thanks. My name's Christina Drzal. I'm a supervising attorney of a regional housing unit at Legal Aid of Southeastern Pennsylvania. We have a really small group today, which is great. So feel free to interrupt me, put in the chat. You know, I'm happy to tailor this program to suit you guys' needs. Basically, what I'm going to try to do in an hour is teach you the basics of landlord-tenant law. Of course, at Legal Aid, we do eviction defense. To talk about that, to answer any of your questions. And I have a host of resources and information on my PowerPoint slide. Mark has it. I will drop it into the chat as well at some point, so you're free to use it. So let me just pull up my presentation. All right. Can everybody see my screen?
Yeah.
Okay, perfect. All right, let me move this over.
Will Mark be able to send it out to everyone?
Yes, and I will also put it in the chat as well.
I appreciate the send out because this way I can print it out and put it in a file.
Not a problem. And I see it looks like we have some people on iPhone, so you may not be able to see my presentation. That's fine. You can access it later. I'll also try to read what's going on. So I'm from Legal Aid of Southeastern Pennsylvania. Hopefully you are aware of us. If not, we cover the 4 counties outside of Philadelphia: Bucks, Montco, Westchester, Delaware County. We provide free legal services to low to moderate income people in those counties. Our practice areas are family law, domestic violence, housing, bankruptcy and consumer law, unemployment compensation, public benefits, Social Security disability, dependency, expungements, and elder law. I have been practicing with Legal Aid. This is my 13th year. My focus is housing. I do eviction defense and foreclosure defense, tax sale defense, basically anything having to do with keeping people in their homes. Again, feel free to interrupt at any time. We've got a small group today. To ask me any questions or anything that's not clear. Our focus, of course, at Legal Aid is on the basic needs of people: family, shelter, safety, and income. Before I get started, I like to do just a brief, the who and the why. Who's being evicted and why do we care? I'm going to start with the why. The first is that evictions are constantly happening. I think in a way it's an epidemic. Pre-COVID, an estimated 2.3 evictions were filed in America. That's about 6,300 people in a day. Of course, the pandemic, evictions have skyrocketed due to the pandemic. The last report that I saw was that about 15% of families renting in PA are eligible for eviction in January. That's a huge number of our neighbors and our friends. Who is this impacting? The biggest impact this has is on low-income people. Poor people spend a higher percentage of their income on housing. 3 in 4 spend 50%, 1 in 4 spend over 70%. So poor people spend much more of their income for housing. In addition, this impacts vulnerable populations. They have higher risks for eviction. Poor women of color, domestic violence victims, and families with kids, studies have shown have higher risks for eviction rates. So we see housing at the intersection of poverty, racial inequality, and the gender gap in a great way to start addressing all of those issues, which is why we focus on it at Legal Aid. The first slide that I'm going to show you is how evictions happen in Pennsylvania. A caveat, this is not all evictions, this is most evictions. Most evictions start at the MDJ, the Magisterial District Justice. That's sort of the lower court. That's the one that's going to be out in the counties. Most evictions start there because it's the cheapest, the fastest, and the easiest way to file an eviction. Technically, you can file an eviction in the Court of Common Pleas, which is the main courthouse, but most people don't do it that way because it's more expensive, takes much longer, and is more difficult legally. So this is most evictions happening in Pennsylvania. The first step may be that the landlord, when they want to evict, gives a notice to quit. Notice to quit is just a fancy way of saying that they're telling you that they want to evict you. This notice, however, is not required. It can be a waived right. So many people sign a lease that says if the landlord is going to evict you, that they don't have to tell you beforehand. They just have to file the lawsuit. After the notice to quit, the landlord must file a complaint. The complaint is just a way of saying lawsuit. When the landlord files the complaint, it's about 7 to 15 days until the hearing is scheduled, is what the law requires. The tenant must receive notice, right, to defend themselves. Tenant must receive notice at least 5 days before the hearing. Then there's the hearing. After the hearing, the judge issues a judgment. That's the judge's decision. The judge has 1 to 3 days to do this, although typically they'll do it on the same day as the hearing. The judge will then, the court will mail you that decision. If you do nothing, if you don't file an appeal, and the landlord can get an order for possession 10 days later. And then after that, the eviction will occur another 10 days later. So that's the sort of simplest way that an eviction occurs in Pennsylvania. If you are evicted by your landlord and you do absolutely nothing, you don't show up to court, you don't file an appeal, or you show up to court and you lose, and you don't file an appeal, the earliest that an eviction can occur would be 21 days from the date of your eviction hearing. Illegal evictions, what are they? By showing you and demonstrating the eviction process, what I hope people are understanding is that evictions must happen through the court. It does not matter that the landlord owns the property. They are not allowed to simply throw people out. You must have a court order to evict a tenant. Evictions are done or executed by the sheriff or constable. So even after the landlord gets a court order, it's not like the landlord throws you out. We actually have an officer of the court do it. Landlords cannot try. An illegal eviction is basically when the landlord tries to get around this process. They try to throw out the tenant's belongings or turn off the utilities like heat and water or take doors and windows off to pressure a tenant to leave the property without a court order. This is illegal. This is considered an illegal eviction. What do you do if you're being illegally evicted? You can call the police and show proof that you're a tenant, right? We often have clients do that. You can call legal aid. Legal aid can file an emergency lawsuit against your landlord to sue the landlord and force them to open the property. You can call the Attorney General's office, and I leave the number there on my presentation. The Attorney Generals, you know, they have the badge. They can call the landlord and yell at the landlord and tell them that is illegal as well. And under Josh Shapiro, they have been more active in doing that. So we've been recommending that to people as well. One thing you can do if you think that you are going to face an illegal eviction, some proactive steps you can take to protect yourself would be to keep proof of your tenancy outside of your home, right? If you're illegally locked out, you don't want proof that you're a tenant stuck in the house. So I tell my clients, keep a copy of your lease in your car or with a trusted neighbor, keep copy of your rent receipts, keep copy of your utility bills with your address and your name, so that if ever you need to show the court that you're a tenant, if ever you need to show the AG's office that you're a tenant or the police, you are able to access your proof easily. Why can a landlord—
There's a question in the chat, Christina.
Oh, sorry, I can't see the chat, so thank you. Let me, where did the chat go?
I can read it for you if you like.
Hold on.
Is it considered harassment or threatening if the landlord only gives a notice to quit without going further?
I would say probably not, no. Because they may have decided, change their mind. I've never seen a court find that or come with that judgment. No, I would say that that's not my experience. Why can a landlord evict? For three main reasons. Tenant doesn't pay the rent. The tenant commits a lease violation of an oral or written lease. Oral leases are valid in Pennsylvania, or the lease term has ended. Why can't a landlord evict? These are your common discriminatory practices that are prohibited by the federal government. You cannot evict someone because they're disabled, because of their race, because of sex, color, national origin, religion, or family status. Those are federal protections throughout the country. In addition, Pennsylvania has some additional protections that they have enacted under state law. For example, you cannot evict someone because they are of their age, 40 and above. And it also, many localities have their own ordinances. For example, I live in Delaware County. Here in Swarthmore and Springfield, they have local ordinances prohibiting discrimination or evictions based on sexual orientation or gender identity. So sometimes you may have some additional local protections. One thing that we litigate and that I think is common in this area of law is reasonable accommodation requests. A reasonable accommodation, so we want to provide fair housing for everybody, including those people that are disabled. To reach that goal, the law allows a tenant who is disabled to request a reasonable accommodation. That's a change or exception to the lease term or landlord's policy or practice to accommodate a tenant's disability. So some examples of reasonable accommodations that I have asked for my tenants. If I have someone in a wheelchair who needs an assigned parking space that's closer to the front door, I may do that. What other some things? I've had people who have disability payments where their payments, they actually receive their check from Social Security, let's say on the second week of the month. So they can't pay their rent on the first. I've asked for accommodations to have the rent paid at a later date. I've gotten that accommodation. One consideration for reasonable accommodations that it must be reasonable in cost, right? I can't ask for them to install an elevator in the apartment to accommodate my client's disability because an elevator installation would cost far too much and the court would probably not find that reasonable in most circumstances. But we do reasonable accommodation requests in some fair housing litigation. To help people with disabilities access housing. So that's one avenue. What happens after court, right? Post-judgment. You go to court, you have your eviction hearing before the MDJ. What happens after their judge makes the decision? There are two basic appeal periods. There's a 10-day appeal period and there's a 30-day appeal period. The 10-day appeal, a tenant must pay the appeal fee. The appeal fee is approximately $300. If you are low income, you can fill out a IFP petition and request that that fee be waived. The tenant must also pay their monthly rent and bond into the court in order to appeal to the 10-day appeal. If the tenant is low income or on Section 8, they can have the bond part waived. So really, if you are low income and you want to do the 10-day appeal, the cheapest appeal that you can do, assuming you can get all the fees waived, would be that you must pay your rents into the court escrow. Nobody can have that waived, right? That is a requirement if you want to appeal within 10 days. If you do all of those things, if you appeal within 10 days, you file the appeal, you pay the costs, you can stay in the property while the appeal is pending. So instead of getting evicted in 21 days, if you do the 10-day appeal, you get to stay until the appeal hearing. And the appeal hearing can be months away. Typically in Westchester, it's probably 4 to 5 months from the day you file the appeal. It could be even longer because we've had a backup in the courts due to coronavirus. So many clients will file the appeal because they simply can't be evicted within 21 days and find a new property. If you don't need to stay in the property while the appeal is pending, you can do a 30-day appeal. This is cheaper and you have longer to do it. However, you cannot stay in the property while the appeal is pending. You will be evicted. You just have a chance to dispute the amount of the judgment. So for the 30-day appeal, you must move out. You must pay the appeal fee, which is $300, or if you're low income, file an application to get that fee waived. So your first option after eviction court is the 10-day appeal. Your second option is the 30-day appeal. In some circumstances, the court, the MDJ, can issue a pay and stay judgment. What that means is if you were sued in eviction for non-payment of rent only, you weren't sued because you damaged the property or had an unauthorized tenant. If you're being sued for non-payment of rent only, the judge can issue an order which allows the tenant to pay what they owe with court costs prior to the eviction to stop the eviction. And we're going to look at a judgment next to explain this and see to make it more real, but I just wanted to go through the rules here. Judgments are important because they're garnishable, they are public record, and they can affect your credit rating. So let's look at a judgment. This is here. If you go to eviction court, this is what you're going to get sent, right? This is what the judge's decision is going to look like. So at the top, you have the case name, you have who the judge is, you have the court information. Some of the important things to look at here. Disposition date. Here, the disposition date, I've circled in pink. The disposition date is 12/17/2019. So if you're going to file a 10-day appeal or you're going to file a 30-day appeal, this is the date that you are counting from. The 10 days and 30 days include weekends, so it's not business days, it's calendar days. If the last day falls on a weekend or a holiday, you get one additional, you get until the next day the court is open. This over here that I circled in this yellowish green where it says disposition details, that's where you find out if you have a pay and stay order. If it says grant possession yes, that means you do not have a pay and stay order. If it says grant possession no, that means you do have a pay and stay order, which means you would be able to pay the judgment in order to avoid eviction. Here the judgment is 0, so it would be a really easy way to avoid eviction. The other thing to look at when you look at your judgment is what the rent amount is. The MDJ establishes what your rent amount is. Here the MDJ established that it's $180. So that's how much you would have to pay into the court every month to sustain your appeal if you did the 10-day appeal. Okay, CDC Declaration. Let me check my time. Oh, good. So coronavirus, pandemic, what are we doing? How has the law changed in relation to that? We've had a number of laws passed and expired. The current law that hasn't expired is the CDC Declaration. In September, the Center for Disease Control issued an eviction moratorium to protect public health due to the pandemic for qualified tenants. So the eviction moratorium does not protect everyone. There are a ton of loopholes, and I'm going to go through who this protects. To enact the CDC Declaration, every adult on the lease must provide a signed copy of the CDC Declaration to their landlord. Here, if I've linked to it, let's just click on it to see. Where did it go? I'll show it to you really quickly. This is it, okay? It's linked in my presentation. Also, if you just Google CDC Declaration, it's going to be the first thing that pops up. Sorry, now, of course, I can't get back to my presentation. Here we go. So if you want to have these protections, you have to get this form, print it out, have every adult on the lease sign it, and then give copies to your landlord. That's the first way to start the eviction moratorium. To sign the declaration, you have to make sure that it applies to you. So who does it protect? It protects people that made less than $99,000 in last year. It applies to people who received the stimulus check, and it applies to people who are not required to file taxes. That may be somebody whose income is only disability or sometimes Social Security. It applies to people who cannot pay their rent due to income loss or extraordinary medical bills. So I think what's important to note here is there is no requirement that there be a coronavirus connection. Some people think that, oh, I can only use the CDC if I got coronavirus and lost my job and couldn't pay. That's not true. It's for people who had income loss. So, for example, I had a client who had an unexpected car repair and had to spend all his money on that to get to and from work, and this took all of his income, so he couldn't pay his rent, so he used the CDC declaration. So there is no coronavirus connection. To use the CDC declaration, you are required to apply for rental assistance. The next slide is about rental assistance. There is a ton of money out there, so please apply for rental assistance if you can. The declaration also, if you sign the declaration, you have to state that you will become homeless or forced to live in close quarters if evicted. That applies to pretty much everybody. You sign the declaration under penalty of perjury, right? There could be consequences, fines, penalties, or jail if you lie. I will say that that's what the declaration says, but I don't say that to scare people. Yes, you should be truthful. Have I seen anybody who's been prosecuted? No, but I do, want to point out that it is a requirement. The CDC declaration protected people to the end of December. Thankfully, a couple days after Christmas, under Stimulus 2, they extended an additional until the end of January. So currently, the eviction ban runs through the end of January. So if this applies to you and you are facing eviction and you cannot pay your rent, please print out the form, sign it, hand it to your landlord. I have clients tell me, Christina, I tried to give it to my landlord. My landlord refused to accept it. What I tell those clients is fine, print it out, sign it. When your landlord takes you to court, hand it to him in court in front of the judge, right? That's hard to avoid. Also bring a copy for the judge. One thing to know about the CDC declaration is there's no waiver of any money owed. So if you owe late fees, fines, whatever you agreed to pay under the rent, none of the rent is waived. This simply gives you more time and protects you from eviction to get caught up in your rent. Because you're expected to apply for rental assistance. Under Stimulus 2, it looks like PA is going to get another $852 million in rental assistance. I put here the 4 service areas that LASP works in. In Chester County, you call 211 for rental assistance. That's the portal, or on the website, you can go to pa211.org. If you are not from these 4 counties, there's some information on the last page that I could show you to look in other counties for rental assistance. But if anybody has experience applying for rental assistance or applied for rental, we had a rental assistance starting from September to December in Pennsylvania. We got $150 million under the first stimulus package. We only managed to spend $50 million, and we returned $100 million in rental assistance. Is that because 100 million people, there was not the need for that money? No, it's because they designed a program that was so challenging and required so much paperwork that so many people couldn't get through the program, which was unfortunate. But they're designing a new program, and hopefully they design a better program. That remains to be seen. So my advice is, I understand landlords are tired of this. I understand tenants are applying. It's a tedious and long process. But hopefully, if you had problems before, you can apply again. There is a lot of money, and they are working on making the process easier, although I don't know if they will be successful. All right, so that's coronavirus, rental assistance, repairs, right? Habitability repairs is a common issue that we see and are frequently litigating at legal aid. My first piece of advice is document, document, document. You know, I know it's hard to do that, but that's what the court is going to expect to see if you're going to want the court to act on your behalf, right? If you're sending text messages, if you're sending emails, if you're sending letters, that could all be admissible, but really you want to document the problem. The hardest cases I see are people who have only been, you know, they may have lived 6 months without heat, but all they've been doing is calling their landlord, and they really don't have any other evidence that they alerted the landlord to the problem. So really for the courts, they sort of expect a formal documentation. So send letters, send emails, send texts, take pictures, do whatever you can to document the problem. In Pennsylvania, we have the implied warranty of habitability. In our law, the Supreme Court says that the landlord must provide safe and sanitary conditions when renting residential properties. This is not a waivable right. So the landlord is required to do this regardless of whether you pay rent, regardless of their financial situation. The law is you have to provide safe housing if you want to be a landlord, and this is not waivable. So I want to make that clear. But it's a safe, and the requirement is that a landlord must provide safe and sanitary conditions. So what is that? Safe and sanitary conditions have to do with safety. So this is not, sometimes my clients will say, oh, the landlord hasn't painted in a number of years. That has nothing to do with safety, right? That's not a requirement of habitability. Or, you know, maybe a couple electrical sockets don't work. That's generally not going to meet this requirement. Safety concerns under habitability, no heat, rodent infestations, raw sewage. Those are all things that would violate the law. So make sure that it is a true safety concern. If you have a repair issue, my recommendation is you send a letter to your landlord outlining the problem and giving them a reasonable amount of time to make the repairs. If they do not, then you can send a follow-up letter. You have these, I list 6 possible solutions. The first one is if your landlord's not making the repairs, complain to code enforcement or your local health department. They have local codes. They can come out to inspect. They can, you know, fine the landlord or force the landlord to make the repairs. I will advise, though, that sometimes this is a double-edged sword. If the property is so uninhabitable, code enforcement typically has the right to condemn the property. If they condemn the property because they find it's not fit for human habitation, they would shut it down in 1 or 2 days, so you would be evicted fairly quickly, and that's not something that we would be able to contest because they have that right. Another option is if your landlord is not making repairs is to do, oh, I think I see a question this time. Hold on. All right. When a landlord makes a repair, can they increase the rent in order to cover the repairs? Not automatically. So whether the landlord can change the lease terms depends on what the lease says. So if your lease says landlord can make changes to the lease by giving you 30 days notice and sending you a letter, then the landlord can do that, right? Or if you have an oral lease, the landlord can send you notice, 30-day notice to make changes to your agreement. If you have a year's lease that says, I have a year's lease and the landlord agrees to rent me the property for X amount of dollars per month, then they shouldn't be able to amend the lease. It's really specific to what lease agreement you have as to whether or not the landlord can increase the rent or change the terms of the agreement. All right. So the second solution that you can do is repair and deduct. This is best for small repairs, right? If you have a repair and deduct issue, let's say my toilet's not working. So I would send a letter to my landlord and say, dear landlord, my toilet is not working. Please come out and fix it. If the landlord doesn't come and fix it in a reasonable amount of time, I would send another letter and say, dear landlord, you didn't fix my toilet, so I'm going to have it fixed and deduct that cost from my rent. I would then go get 3 estimates for the repair, have it repaired, pay for it, and then send the receipt with any difference in my rent to the landlord, and then continue to pay my rent after that as it comes due. So that's one option which can be good for sort of low cost repairs. Another option is to escrow your rent. Same thing, dear landlord, there's a leak in the roof. Please come fix it. Give the landlord a reasonable amount of time. If they don't, dear landlord, the roof is leaking, you haven't repaired it. So starting February 1st, I'm going to start to escrow my rent. And then you would be required to put your rent into the court escrow every month when the rent is due to pay. And you pay your rent into the court escrow when it's due, you pay in full. You cannot commingle the funds with other money of yours. You cannot take the money in and out. You simply have to let the money sit in there. So that's one option to leverage against the landlord to try to force the landlord to make the repair. If the condition of the property is so bad, you can terminate the lease and move out and say, at this point, you know, it's raining through the roof, I've got sewage in the basement, I don't want to wait for your repairs, I'm simply going to terminate the lease and move out. In that circumstance, of course, document. I would always recommend you send a letter outlining to the landlord that you're terminating the lease, when you're leaving, and why you're doing it. You can file a lawsuit for damages, right? Dear landlord, I had all my belongings in the basement and I told you about the leak, you didn't repair it, and now all my stuff is damaged. So I'm going to sue you for what I think is the cost of my belongings. I saw one question, hold on. Where did that go? Getting better at this. The question is, so local MDGA court will collect escrow payments if no complaint is pending. No, the court has nothing to do with escrowing your rent. You would open a escrow account at your local bank or savings or some other savings account. This is not done through the courts. This is just you escrow your rent on your own. So you can sue for damages, right? You just sue and say, my belongings were damaged, I want X amount of dollars to compensate me. Lastly, you can request specific performance, although this is asking the court to require the landlord to do something. I never see the courts do this because they typically don't want to get involved in supervising repairs because they don't have the time or the staff. So even though technically this is an option under the law, in my 13 years of doing this, I've yet to see the court do that. So it's probably not really going to happen. In addition, for repairs, if you are sued for an eviction at any time under PARCP MDJ Rule 508, at any time before the hearing, the defendant may file a cross complaint asserting any claim against the plaintiff which arises out of the occupancy of the premises without paying a filing fee, right? So if your landlord sues you for eviction and you're saying, wait a minute, I went 6 months without heat and you know there's a broken window, then you may want to file your own free cross lawsuit against your landlord to raise that claim because you're going to be in court anyways. I will say, if you're going to escrow your rent, I always have this discussion with my clients, escrow proportionally to the damage. If I am in a 3-story unit and only the first floor doesn't have heat, then I would withhold or escrow 1/3 of my rent and I would give my landlord the other 2/3 because you have use of 2/3 of the property. It shouldn't be that you pay nothing if you have some use of the property. The escrow should be proportional to whatever damage you are incurring. All right. See how I'm doing on time. Okay. Oh, good. Briefly on subsidized and affordable housing, I'm not going to get into that detail. That could be a whole other webinar, but people in subsidized or affordable housing that's paid for in part by the federal government. For example, Section 8 public housing, project-based vouchers, elderly and disabled housing, low-income housing tax credit, USDA rural housing programs. All of those programs have some payment that is received from the government. Those tenants typically have higher rights. Their rent is capped at 30 to 40% of tenants' income, except low-income housing tax credit, which is a little bit higher, generally 40 to 45, I think. Tenants have additional due process rights. They may be entitled to additional hearings. There may be more limited reasons as to why they can be allowed to be evicted, as well as these types of tenants can file complaints directly with HUD on HUD's website, and I give you the link there to HUD.gov complaints home, so you can file additional complaints against them for people in subsidized housing. Security deposits can be up to 2 months' rent in the first year. After the first year, 1 month's rent. So if you have been in the property, that's because the law acknowledges that if you've been there a year and there's no damage been caused, then the landlord should return some of your money. There's less of a need for a security deposit. So after the first year, you can ask for 1 month's return of your security deposit because your landlord can only hold 1 month at that point. To get your security deposit returned, when the tenant moves out, they must give their landlord the forwarding address to send the security deposit. The landlord has 30 days to respond and return the deposit or give an itemized list of damages plus the difference. If the landlord fails to respond in writing within 30 days, they waive the right to sue for damages. Although there has been some recent case law sort of chipping away, so that's not always necessarily true, but it can be true, and certainly I make that argument frequently, and the courts find that as well. If the landlord wrongfully withholds your security deposit, you have a right under the Landlord-Tenant Act to sue for 2 times the amount of your security deposit that's wrongly withheld. My resources page, do you have enough time? Okay. How to apply to legal aid of Southeastern Pennsylvania. We have a helpline that's open Monday through Friday, 9 a.m. to noon and 1 to 4. The number is 877-429-5994. Again, that's 877-429-5994. You apply for assistance, and then we would connect you with an attorney that specializes in the area of law that you need. You can also apply online at www.lasp.org/apply. You can apply there 24 hours a day. Some additional resources that I put on my resource page. There's palawhelp.org. That's a website run by all the legal aid organizations in Pennsylvania. It's wonderful. It has a lot of DIY legal information. It's a great way to educate yourself, a lot of forms. We try to put as much information there to help people help themselves. In addition, there's the PA courts. I'm going to actually go to that website if we have a little time at the end. It looks like we do. So let me circle back to that. There's Regional Housing Legal Services. They're a housing program in Pennsylvania, a non-for-profit focused on housing. They're great, similar to last website. We try to put as much information up there about eviction moratoriums, tenant rights, anything of that nature. The Housing Equality Center of PA, they do fair housing litigation. So if you've been discriminated against because of your race, gender, any of those things, they do investigations where, they send 2 couples of different races to the house to try to rent it to see if there's discrimination. So if you're facing those problems, we partner with the Housing Equality Center all the time. They're wonderful. They have a lot of information on disability rights in terms of housing, so we partner with them frequently. National Housing Law Project also has a lot of good information, up-to-date information on coronavirus protections. The law is constantly changing regarding the coronavirus and eviction moratorium. So it's always good to check back, because there's always, 2 days after Christmas, we get a new law. There's always new stuff coming out, and as advocates, we're obviously constantly pushing for that. Pennsylvania Utility Law Project, they're great. There have been many laws prohibiting utility shutoffs. There are many programs providing utility assistance. LIHEAP is going on, which is utility assistance as well. They have all the information there about utility rights. PA Housing Finance Agency, phfa.org. They're the state agency. They do mortgage assistance there, and they often have information about rental assistance, so they're very useful. Since we have a little time, I'm going to just show you quickly the PA Courts website, because I think it's really good to show people how to look up their own information. So if you go to pacourts.us, let me see, hopefully this works. It takes you to the AOPC website. This is the website of the Pennsylvania courts. So it has everything, a lot of information here. I'm going to first show you, if you look up here on the right, there's a forms tab. This is a really great place for people to go. There's for the public forms, excuse me. I'm going to click on that. It's loading slowly, hold on. Huh, why isn't it working? Oh, there it goes. All right. Here, there are a bunch of really great forms, and I'm going to go through them. It shows you the notice of appeal form. It has forms if you're appealing and you are low income to pay your rent into the court escrow. It has the cover sheets. If you want to, here there's a civil complaint. If you have a claim against your landlord, a claim against anybody, you can fill this form and file it with the MDJs. The maximum amount of your claim can be $12,000, but the form is right there, so it's fairly easy. The other good forms are informa pauperis. If you're applying to have fees waived with the court, this is the form that you would need to complete. And what else? Those are the ones that I use the most often. I'm going to go back to the first page and also show you how to access the public docket. So if you go to courts and then you go to docket sheets, if you go to court cases, magisterial district courts, I like to scroll down. Put a participant name. So we'll say Sandra, oh no, first name, Sandra Jackson. And then we want to look to see if she has a landlord-tenant action filed against her. Search. Wait for it to come up. Yes, so these are all the evictions against Sandra Jackson's in Pennsylvania. You can click on the left to see the docket sheet. And it will tell you about the case. It'll tell you about the judgment, the date, if there was any upcoming hearings, it would be here. And I show you this because one, it's good to have access for tenants to have access, to their own court case, to know about hearings, to know what the judgment is, but also to demonstrate how easy it is to look up people's landlord-tenant history, how easy it is to look up people's criminal history in Pennsylvania. We have very open records, which is both good and bad, because having a landlord-tenant eviction on your record certainly makes it much harder to find a new place. So that's one thing that I encourage people to think about as well. But I think that's most everything. Do we have any questions?
And feel free to unmute yourselves at this time.
Yes. Did I mute people? I don't know how I did that.
Thank you, Christina. This is Roland and Mark. You have our email addresses, because this overview that you did for us is extremely helpful. And rather than taking tedious notes, I'm going to print it out. And
yeah, and I will attempt to put it in the chat right now. Sometimes I'm successful at that, sometimes I'm not, but I will try to see if I can do that.
And I will email it out to everyone who registered for today too.
oh, fantastic. That's
All
great.
right, and I just threw it up in the chat too. So yes, hopefully, you know, if you are a tenant, you know, I want to say that we are inundated with evictions. You know, we are in a recession, we're in a pandemic. Lots of people are in this situation. Please feel free to reach out to legal aid for help. For eviction defense and really any legal matter, we partner with many other organizations, so if we can't help you, we certainly try to send you in the right direction. All right.
Yeah, this has been extremely helpful. Unbelievable.
I'm glad to hear that.
Very good. If no one has any questions, thanks so much again, Christina, for this.
No problem. Take care, guys.
Thank
Great
you.
information.
Look
Thanks.
forward to
Take
getting
care,
it.
everybody.
Take care. Thank you, Mark, for everything. And I appreciate, as soon as you get the email out, I will print it here.